SJC-13434, Six Brothers, Inc., and others, the Town of Brookline, and others.
Okay, looks like people are settling in. Attorney Tinsley, whenever you're ready.
Thank you, Madam Chief Justice, members of the court. May it please the court, I am here on behalf of Six Brothers, Inc. and other tobacco retailers in the town of Brookline, appealing from a decision of the Superior Court dismissing our complaint.
We know why we're here.
Yes, Your Honor.
Can we just dive in to Chapter 270, Section 6? I completely agree with you, and I'm not sure the appellees disagree with you, that the ordinance, the bylaw clearly relates to minimum age.
Okay, thank you, Your Honor. I didn't belabor that section of my brief because I did think it was somewhat intuitively obvious, so I appreciate that.
So that seems clear enough. But the statute doesn't just say that. It says this act shall, it doesn't say preempt state or local law related to minimum age to purchase tobacco products. That's not what it says. It says this act shall preempt inconsistent, contrary, or conflicting state or local law related to minimum age. And how is it inconsistent if the whole purpose and thrust of the statute is to try and address the harm of tobacco and the perniciousness of addiction as it relates to society and particularly young people?
Well, it's a good question, Your Honor. I think it takes us back into the statutory intent, because I think that's one of the errors that the Superior Court fell into here, is oversimplifying what the statutory intent is here. On the one hand, there is an intent to protect the citizenry from the dangers of tobacco. That much is clear, and the statute does have the effect of raising the statewide minimum age for purchasing tobacco from 18 to 21. So there is movement under the statute in the direction of promoting restrictions on the sale of tobacco. But that doesn't exhaust the statutory intent, Your Honor. As you can see, the legislature takes special pains to ensure that as the state minimum age transitions from 18 to 21, no one anywhere in the Commonwealth who had previously attained the minimum age to purchase tobacco and whose local community permitted persons of that age to purchase tobacco to then forfeit the right. So the state legislature was very careful to make sure anyone who could already purchase tobacco lawfully would still be able to do so in the aftermath of the statute. So what that shows, Your Honor, is that restricting the sale of tobacco was not the only intention of the legislature, and any and every restriction on the sale of tobacco is not automatically consistent with this statute. What the statute does, Your Honor, it sets a floor and a ceiling for the sale of tobacco statewide. And one of the primary intentions of the legislature in doing so was to overcome the confusing and bewildering patchwork of laws that permeated the Commonwealth.
Say that other than the comments of two legislators.
Oh, I think the governor's statement, when the governor signed the statute, Your Honor, in addition to the two legislatures, the governor also stated quite clearly that the time had come for a statewide, uniform standard on the area of age restrictions on the sale of tobacco. So I do think, were the town's interpretation of the statute correct, one of the implications would be that the governor who signed the bill didn't even understand the statute he was signing. So I want to suggest
that's the danger of the kind of legislative history that you're trying to ask us to do, where we rely on the statements of 2, 3 people to determine the intent of the statute.
I think, Your Honor, would be quite right. If all I was coming forward with was a handful of scattered quotes from legislatures, you're quite right. The fact of the matter is, though, Your Honor, those quotes clearly illustrate what is already present in the plain language of the statute.
So yeah, let's focus on that. Where does
Absolutely.
the plain language prevent the town of Brookline from, over time, eventually prohibiting the sale of tobacco to certain people?
Well, Your Honor, what the statute does
Can you do can you focus on the first sentence first as you answer Justice Wentland's question? Because that's, seems to me your best argument. This act shall prevent any inconsistent, contrary, or conflicting state or local law relating to the minimum sales age. So when Brookline changes the minimum sales rate age to 23 or 24, is it your argument that's inconsistent with the first sentence of this?
Yeah, yes, Your Honor. And
This is not a
the state
masterpiece of
legislature
clarity.
thought so too, Your Honor.
Well, you,
That's why if you see in section.
before you talk about legislative, tell me how is that what are you just reading that first sentence to say that that prevents anybody from imposing a higher, any town or the state, any town from imposing a higher minimum age, meaning 23, 25, 30, 90, whatever?
Yes, Your Honor, or lower, for that matter. It would also equally prevent any town from lowering the age to 15 or 16. But yes, it specifically for our purposes here, it prohibits a local town or city from raising the minimum age to purchase tobacco above 21.
And I understand then how but then how do you, what does the third sentence mean then?
I don't have the statute
This
right in
act
front of
shall
me.
not
Not a-
otherwise preempt.
This act shall not otherwise preempt the authority of any city or town to enact any ordinance, bylaw, or any fire, health, or safety regulation that limits or prohibits the purchase of tobacco products. So what's that about?
Well, I think what that's about, Your Honor, is local cities and towns have robust authority to regulate, limit, and even prohibit the sale of tobacco products. But the legislature made it clear in this statute, Your Honor, that cities and towns cannot do that by manipulating the minimum purchase age for the
Meaning
sale
they
of
can
tobacco.
ask for 2 IDs?
Age restrictions.
But what does it mean? Meaning they can say, give me 3 IDs or come with your mom? I don't understand. What does that mean?
I'm not sure about that, Your Honor, but I think the key word is otherwise. When you understand the statutory language that Your Honor just recited, what it's saying is that cities and towns may not regulate or prohibit the sale of tobacco based on age. That is the exclusive prerogative of the state legislature. Otherwise,
Meaning they're
cities
not
and
allowed,
towns have
meaning they're not going to allow them to be sold in grocery stores, or they're not going to be.
no age restrictions.
bars?
No age. Oh, so is Your Honor asking?
I'm just trying to get. I don't find this statute very clear, so I'm trying to understand how the 3 sentences work together.
Here's how I understand it, Your Honor. If a city or town voted to prohibit the sale of tobacco altogether, that would be their prerogative under this State Tobacco Act.
But doesn't that inconsistent with your first argument, which is that, because that means that they've basically made a minimum age of everybody there. If you can't sell to anybody, isn't that going to be a violation of the first sentence? Because then there's, I don't know, I'm just.
No, I think what the State Tobacco Act is designed to do, Your Honor, is to leave cities and towns with some significant discretion in the area of prohibiting or regulating the sale of tobacco, except as it pertains to age. Age-based restrictions are reserved to the state legislature.
Why is this an age-based restriction?
It's an
The
age-based.
restriction that's based on birth year. So no matter how old these particular people get in the town of Brookline, they will never be able to purchase tobacco.
You're correct, Your Honor, which is one of the reasons we believe it offends principles of equal justice.
But first, tell me why this is age-based restriction. If it says you people born before 2000 or after 2000 shall not be able to purchase in our town tobacco.
Well, Your Honor, the statute relates to the minimum age for the sale of tobacco products because of what Your Honor just mentioned, because it refers to a specific date, January 1, 2000, and indicates that only persons born before that date have the right to purchase tobacco products in Brookline. So individuals born on or after January 1, 2000 will never attain the right to purchase tobacco in Brookline.
Regardless of their age.
With one exception
But
that I
again,
do get into
but
in
isn't
my-
is before you leave Justice Wetlands, because that's what I can't figure out. Is it regardless of age, or does this mean ever and ever higher increasing percentage of people will now be banned from buying cigarettes? So it is related to age.
Gradual prohibition.
Absolutely, it's related to age. And that's right. As a practical matter, in Brookline today, you need to be 23, more than 23 and a half years old, let's say, in order to lawfully purchase tobacco. Next year, you'll need to be 24 years, and the year after, you'll need to be 25 years old, and so on and so forth. So, yeah, the statute plainly relates to the minimum sales age for tobacco products because it effectively establishes a minimum age in Brookline for purchasing tobacco, and that minimum age increases every single day and every single year.
The AG suggests that it's only inconsistent if you provide something lower than 21. Right? I think that's their gloss on this.
It
Why
is.
is that not right? That cigarettes are dangerous. The legislature was focused on that problem, and the only things inconsistent are ones that lower it below 21, but you have to be 80 to buy it.
Well, a few things, Your Honor. One, as I mentioned at the outset of my remarks, I think it's an oversimplification to say that the legislature was exclusively concerned with the dangers of tobacco. They were also concerned with this bewildering patchwork of laws that had sprung up across the Commonwealth, where the minimum age to purchase tobacco was 18 in some communities, 19 in others, 21 in others. And so it was a difficult situation for retailers to operate in, and that is one of the concerns that the legislature took up. So in the prior state statute that established the age to purchase tobacco at 18. So that was 1985 when the state legislature set the age to purchase tobacco at 18. At that point in the statute, there was no preemption language at all. So cities and towns were free to piggyback on top of the minimum sales age of 18 and raise it to 19, 20, or 21. And that's what communities were doing. That is exactly the situation that the legislature was responding to. So if the legislature wanted to continue to permit cities and towns to enhance the age-based restrictions on the sale of tobacco, they didn't need to introduce any language here on preemption.
But here, maybe this is related to my first question. Here's the problem I see. I agree with Justice Kafka, this is not the clearest statute in the world, but right off the bat, it's making it clear that the legislature intended to create some category of laws regulating tobacco where the minimum age isn't subject to the preemption. Because it says this act shall preempt only certain types of bylaws, those that basically conflict. So the legislature intended to have some category of local laws regulating tobacco purchases by minimum age that weren't preempted. The first sentence says that, right?
Well, yes, Your Honor.
Some aren't preempted by the nature of that
Yes.
language.
Well, I would put it slightly differently, and I don't mean to quibble, but I think all state and local age-based regulations are preempted initially. Then the statute rescues a small subset of those local laws from preemption.
But that's
The
not what it
only
says.
ones.
But that's not what it says. It says you shall preempt as it relates to, yes, to certain, but not if it's not inconsistent, contrary, or conflicting.
What's important to notice here, Your Honor, is it's very clear from the statutory language here that there are some local bylaws that would be both more restrictive than the state statute, but also expressly preempted by the state statute. So if you look at the language, the state legislature talks about how local bylaws that set a lower minimum sales age at 18, 19, or 20, in which were in effect already on December 30 of 2018, it's only the bylaws that meet both of those criteria that are rescued from preemption. Now, we know the statute at issue here was not already on the books in 2018, so it doesn't qualify to be rescued from preemption under that provision. But what's really critically important about that language is to understand the state legislature included local statutes that already set the age at 21. Now, why would those local statutes be preempted? They would only be preempted if they're more restrictive than what the State Tobacco Act was permitting. And that's clear from the language. The state is very clear that local communities cannot apply age-based regulations retroactively to prevent persons who were 21 or 20 from lawfully purchasing tobacco if those restrictions weren't already on the books. So
Can I ask,
those would be more restrictive than what the state allows, but they're expressly forbidden.
I've got one concern. I hate to ask this at the end, but can states ban cigarette smoking altogether without running into federal preemption issues?
I don't think so, Your Honor. And to be candid, if the state did pass a total ban on tobacco sales, I would probably be here arguing against it on behalf of these same clients. So no, I
We
can't.
have no briefing on this issue, but
Correct.
I'm a little nervous that the AG's interpretation allows for a total ban on cigarettes if municipalities act uniformly. I just don't know, is that legal under federal?
To answer the question briefly, I think the answer is no. A total ban on tobacco would not be lawful. But this particular...
We're going to lose you quickly. Are there cases that say that? Is there somewhere we can look to, because we're left without any briefing on something that may be important.
Yeah, I don't have that issue briefed, Your Honor. If the, we'd be happy to do the briefing if the result of, this appeal is that the case is remanded for further proceedings in Superior Court. We could certainly brief the issue. But I think the essential point here is just to understand that the State Tobacco Act very clearly contemplates that there could be more restrictive age-based local laws that are expressly preempted by this statute. And that's what we have here. The fact of the matter is...
But you say all of them are. You say every one of them
Every
is.
one that is not identical with the terms of the 2018 State Tobacco Act, which has a practical effect. There was no statute in any local town or city at the time that the State Tobacco Act was promulgated that identically matched its language. So yes, as a practical matter, every single state and local age-based tobacco restriction was expressly preempted in 2018.
Okay, thank you. Okay, Attorney Banton.
If it pleases the court, good morning. I'm here for the Public Health Advocacy Institute. It's a nonprofit organization that supports public health through the law. I'm here with my colleagues Mark Gottlieb and Andrew Rayner on behalf of Brookline, all presenting the oral arguments. The Brookline bylaw is not inconsistent with the minimum age law and therefore is not preempted. Consider for a moment how the Brookline bylaw operates. For the closed group of exempted individuals, nothing will change. Therefore, there can be no inconsistency if nothing changes. For everyone else in Brookline, tobacco products are forever banned, something which is expressly allowed in the last sentence of Section 22 of the minimum age sales law. The Brookline bylaw is no more than the sum of these two parts, both of which are consistent with the minimum age sales law. Therefore, there's no
Walk me through how it works
preemption.
with the statute, though. Why doesn't this, and I just don't understand how what the statute means. The first sentence says, this act shall preempt blankety blank, any local law relating to the minimum sales, inconsistent, contrary, or conflicting state or local law relating to the minimum sales age to purchase tobacco products. This new law is raising the minimum age gradually to the point where it renders everybody too young to buy.
It's a novel law.
Very clever. I just don't know if that's legal.
The appellant's position relies on the Brookline bylaw being thought of as a minimum age law, but this would be.
But it is. It clearly is. It's raising. There's no doubt it's brilliantly raising the age. Again, I don't know if that's legal under federal constitutional law, but it's. By the way, can the state ban smoking without violating? You guys are we've got the greatest cigarette lawyers in the country in front of us. Is this illegal under federal law for the state to ban smoking?
Well, the state certainly can ban it.
Can?
It can. The state, if it wanted to, could ban the sale of tobacco products. Tobacco products are regulated at the federal level by the FDA through the Family Smoking Prevention Act. And that act, Congress specifically preserved for the states the right to regulate the time, place, and manner of tobacco products,
Time, place, and manner. Does that
including a full,
including a total ban?
including a total ban. The FDA sets manufacturing standards, but the Commonwealth can certainly say, thou shalt not allow those products to be sold here, as they have with flavored products.
Are there cases that we can look at right on point that you know off the top of your head?
There's a U.S. Supreme Court case that's many years old. I can't remember the name of it, except it's Tennessee versus something. And the U.S. Supreme Court said a state can ban the sale of tobacco products.
I don't know if you've addressed the appellant's argument here, but they're saying that the Brookline law is inconsistent. And one of the reasons they say it's inconsistent is because what the statute did was say, all right, if you could buy tobacco, don't worry, you can still buy tobacco. And that's not true with the Brookline ordinance.
It is consistent, Your Honor.
But that's what their argument. That's one of their arguments. You understand their argument's a little bit subtle, but their argument is that this statute, the statute in question, Chapter 270, this statute did a number of things. But one of the things it did was, hey, don't worry, if you could buy tobacco before, you're still good. And that's not true in Brookline. And that's inconsistent and exacerbates the problem of lack of uniformity. That's one of their arguments. I'm not sure you address it.
Your Honor, are you referring to the small group of individuals who had the right and then briefly lost it? Or are you referring to the people who were the exempted?
There were people who had the right and briefly lost it, which is inconsistent with the statute, which was protecting them. The December 31st, 2018.
There was a small group, if I understand Your Honor correctly.
Small group.
There's a small group, correct.
Who had it.
Who had it and then lost it, that's right.
Saying that that's inconsistent.
Well, that would be inconsistent except for the last sentence of Section 22 of the 2018 Act that created Chapter 270, Section 6, minimum age sales law. That last sentence said the towns can ban the product because a ban will be conflicting with the minimum age sales law. But you can do that, town. We're going to preserve for you that right. So there's no conflict here.
Okay.
It's specifically in the safe harbor.
They infuse into the word other a different meaning.
Well, to understand, it's a confusing provision, but if understood in the terms of otherwise, is simply there to delineate the boundary between the scope of preemption and anti-preemption. And if you read those two sections.
Or it's to say minimum age you can't fool around with because we've raised it to 21. But you can do anything else on cigarettes. You cannot allow them in packy stores, or, I don't know, honestly, I don't know what,
Require 2 IDs.
Or banning them.
well,
Or-
that's,
Or banning them, as it says in the section. So I agree, it's saying, you know,
but you don't ban, Brookline doesn't really ban them. They decide to escalate the age. They change the minimum age.
well,
Well,
I
Brookline
don't think
has
they do change the
divided-
minimum.
Has divided Brookline people
Pardon me?
into 2 age groups, right? Brookline has divided those who can buy tobacco, those born, I guess, before 2000, and those who can't.
That's correct. This is not a minimum, this would be the strangest minimum age that anyone anywhere has heard of.
An artfully written minimum age designed to not say we're raising the minimum age, but
Well, there's
actually do the exact
There's a
same
big
thing.
difference between telling a teenager, you need to wait till you're 21 or some other minimum age, as compared to, you're never going to have the right to purchase this product.
Right.
And if we look at the other group of individuals, those who are the closed group of exempted individuals, well, they're not getting any younger. So the minimum age has no meaning for them. It's behind them. So it's minimum age, the notion of a minimum age, that of coming to assume a risk, that's not happening here. So it's completely fundamentally different from
Can
the
I
state's minimum age
Ask
law.
you to go back to Justice Lowy's question about the few individuals who could purchase tobacco products in Brookline. I thought Brookline's law in 2018 was minimum age 21. So there actually weren't this pre-existing people who had the right to purchase in Brookline. Do I have that wrong?
There was some delay. There was some delay during COVID in the effectiveness of this, but it was designed to be right on the point of, when you're 21, you can lawfully purchase. You will forever be able to lawfully purchase. If you've never lawfully purchased, attained that age, the product will be banned forever. That was what it was designed, but there was some, my understanding is there was some.
You would just say the small window that happened to be by chance could not mean that somehow this regulation bylaw is preempted.
Well, I would, because the town could, if they wanted to, have done a complete ban on the product. So in essence, that's what they have done for that group, the more traditional notion of a ban.
Is the uniformity point, you find no merit whatsoever to the uniformity point, I take
The
it.
patchwork.
Because now we're going to have, I mean, we could have every town in the Commonwealth could have its own minimum age rule now, right?
Well, if I may respond in 2 ways. First, I cite Boston Water Sewer Commission v. Metropolitan District Commission. This is not in the briefing. Citation 408 Mass 572. Statements of individual legislators as to their motives concerning legislation are an inappropriate source.
I agree with you. And
okay,
I also agree that the governor is not the legislature, although the governor
Yeah.
is perhaps quite informed on what the legislature is doing. But there is a uniformity element to this.
So what about if other towns adopt this policy? I understand. So just honestly, answer that. The legislature foresaw that and allowed it anyway with respect to banning products, so there would be a patchwork. In fact, we have several examples of this. Alcohol, marijuana dispensaries. Some towns allow them, sometimes don't, and that's okay. That's the way it was set up. I'd make a few other points here, and the one is, much of our briefing has spent the time trying to delineate the boundary between anti-preemption and preemption, and I may be repeating myself here, but the Brookline bylaw is squarely in the safe harbor, the last sentence of section 22. And with regard to the equal protection, I'll just mention that there's no fundamental right involved here. The purchase of a product is not a fundamental right. and there's no suspect class. Neither one is claimed to be in the complaints or any of the briefing. It's just a notion of some sort of quasi class here that needs extra protection. And respectfully, the appellants have not cited cases to support that. The last thing I'll mention is that, of course, we are dealing with a product that has created one of the leading public health problems in this country, a product that is highly addictive and frequently kills the user. And so if there's any question about what Brookline is motivated to do, it is to protect the public's health from what this court has acknowledged many times is a leading public health threat.
But not enough.
Not enough.
Have to ban it altogether in Brookline.
Pardon me?
I mean, the problem with your policy argument is that you haven't banned it altogether in Brookline, right? So,
Well,
so there's some people who are expendable and who could be addicted, but for these ever increasingly aged group, they're going to be protected by the town.
We have learned in public health recently, and tragically, that we're coming to understand that addiction is a disease. It's not some source of moral judgment. It's a disease. And so accommodating, not punishing this group is the appropriate step here. So the hope is that they can be treated through the medical system or quit. But to have someone just stop is problematic, as we know.
You don't really make a very enthusiastic argument, but you make one, and we might have to address it, concerning standing. How can they not have standing when the plaintiffs, when they're directly impacted by the bylaw?
Well, Your Honor,
And I guess also to add to that, how do you have standing if they don't have standing? Because you're also, you're from this advocacy group, right?
well, if we both need to have standing, then we have standing. But we represent represent the town of Brookline, so we have
They
them.
are good. Why aren't they good? They're impacted directly by the bylaw.
Yeah, yeah. Well, Your Honor, standing requires that either it's a right that the individual has, or that the economic interest is so involved that they can claim standing. Here, I would say that economic interest is somewhat attenuated. And here, I think it's important to inject into the consideration the purpose of the bylaw to protect public health, and it has some relevance in this interpretation of standing.
But it's also to allow commerce, limited commerce consistent with the bylaws, and these are the people injured by the limitation.
Yep.
They're-
There is a balance. There is a balancing there.